Thank you for joining us. My name is Elizabeth Aloni, and I'm with Schneps Media. Schneps Media is the largest local media company in New York Metro. We publish over 70 newspapers, magazines, websites, webinars, podcasts, and events throughout Queens, Brooklyn, the Bronx, Manhattan, Westchester, Long Island, and Philadelphia. Today, we are thrilled to bring to you 5 important documents everyone should have. And I am honored to introduce you to AARP's Bernard Macias. Welcome, Bernard.
Thank you, Elizabeth. Greetings, everyone. On behalf of AARP New York, I would like to welcome you to the 5 important legal documents everyone should have webinar. Again, my name is Bernard Macias, and I'm the Associate State Director for Community Outreach and Engagement for AARP right here on Long Island. I serve close to 500,000 members across Nassau and Suffolk. A little bit about AARP. We're the nation's largest nonprofit, nonpartisan organization dedicated to empowering Americans 50 and older to choose how they live as they age. AARP works to strengthen communities and advocate for what matters most to families, with a special focus on health security, financial stability, and personal fulfillment. So if you remember anything, remember health, wealth, and self when you remember AARP. In today's uncertain economy, planning for a financial future is more important than ever. And that's why at AARP New York, we're proud to sponsor Schneps Media 3-part webinar series on financial wellness to give you the information and the tools that you need to protect yourself and your families during these uncertain times. The webinars are going to cover a wide range of topics, anywhere from guardianship action, things you need to know about community Medicaid laws and understanding the power of living trust. We have our first webinar today, but we also have another one coming up on December 9th and a last one on December 16th. So be sure to visit back at schnepsmedia.com/webinars to register. You have to register in advance. So again, thank you so much for joining us today for our first webinar on 5 important legal documents everyone should have to protect your assets.
Thank you so much, Bernard. That was wonderful. And thanks again to AARP New York. Now it is my great honor to introduce you to the top elder law attorney of Ronald Fatoullah Associates. We have with us today, Ron Fatoullah. Hi, Ron.
Hi, Elizabeth. Thank you so much, Bernard. And, I feel like I'm in the company of, it's like family here, because I was on the Executive Council of AARP for 5 years. I just finished my stint, and what a great organization. The resources that they provide, it's just enormous and wonderful. And to Vicki Schneps and Josh Schneps and the group at Schneps Media, I don't even know where to begin with the information that they provide everyone, and just being on top of the pulse, for where you are locally. Throughout New York City, Long Island, it's just unbelievable. So thank you so much, Elizabeth. I'm going to actually share my screen, my slides, if you don't mind. I'm an elder law and estate planning attorney, and I'm in private practice, despite all of the work that I do with Bernard and with Schneps Media. This is my information and my law firm, and the funny spelling of my last name. Let me just see if I can, here we go. Now, when we talk about documents, it's very interesting. Bernard mentioned guardianships. And if someone does need a guardian, need to go into court to have someone else step into their shoes to make their healthcare decisions, to make their financial decisions, etc., that's fine if it's needed. However, we want to try to intercept that and try to see if we could avoid going in for a guardianship. So these are the 5 most important documents that I'm going to be talking about. And I'm going to be getting into depth with some of them. And you're going to see how, for example, having a special planning power of attorney with a statutory gifts rider. I'll explain what that is. A good healthcare proxy and a living will can actually, if you have those documents signed in advance, then hopefully we could avoid a guardianship where the court would actually name a guardian to make decisions for you if you can't make them one day in the future. So why have a court make that decision when you in advance can actually choose who you would want to represent yourself? Now, it's a funny thing that we call these documents advance directives, being facetious, but that's what it is. You sign these documents in advance to appoint these people in the future should you need them. So I want to start off with one of the most important things I think you need to get together. When you want to do planning, and almost everyone that I meet, everyone wants to plan. Some people are too afraid to go into the elder law attorney's office or the estate planning attorney's office. They feel a little superstitious. If they start to plan, something might happen. Doesn't work that way. Whatever's going to happen, happens. Try not to be superstitious about it. And I guarantee, and I hear this all the time for the last 35 years plus that I've been doing this, people walk out of my office and say, I feel so relieved. Finally, I checked that off. I did my planning. I feel so comfortable. Now, the first step with the plan is to get your team together. You need to get your attorney together, your estate planning and elder law attorney, such as myself, together, whoever it might be. Make sure that it's someone who's highly qualified and basically specializes or concentrates in this area. Number two, you want a financial advisor that, believe it or not, also concentrates in either elder law or estate planning. The attorney and the advisor must work together. That financial advisor must know the details on the, excuse me, I think I have to let someone in. Nope, okay, I'm good. Whoops, let me just get back here. That financial advisor has to know the details on, for example, the living trust. How are those assets supposed to be managed? How are those assets supposed to be managed prudently so that the trustee is not going to get hit with a lawsuit? How are those assets supposed to be distributed? You have to understand the details in that trust. So a financial advisor and the attorney must communicate. And the advisor really doesn't have to be a lawyer. A lawyer would be a good thing, but must understand the living trust and all of these documents to a T. The CPA, need a CPA, you need somebody who's going to do the tax planning, the preparation. There are income taxes that's never going to go away. Believe it or not, you know, we deal with a lot of estates. Even when you die, you have to pay income taxes. So it's called income taxes with respect to a decedent. You could never, there's never a situation where you're not going to be paying taxes, income taxes, estate taxes, gift taxes, capital gains taxes. In this series, we are going to talk about taxes, and you'll see how all of this meshes together. And you're going to be armed with knowledge so that you'll understand how to prepare, some of the questions to ask when you see your attorney, your advisor, your CPA. And I've also added a geriatric care manager. If you're older or younger and you need some assistance with planning your care, coordinating your care, or you need somebody to monitor, you may want to think about a geriatric care manager who could step in and help. Now, all of these individuals have to understand the documents and basically what they say. The financial advisor who may be managing assets has to really know these documents in detail. So today we're going to be talking about the last will and testament, where your assets go when you pass away, a special planning power of attorney. not just the form, we'll get into that, and a separate statutory gifts rider, all with extra provisions that so that the agent on that power can actually do virtually anything that you could have done. But if you become incapacitated one day, or you're not available, or even if it's a good thing, if one day we could go traveling and you're taking a trip around the world and having a great time, but you need something taken care of in New York, you can get it taken care of anywhere with these documents. The healthcare proxy is a fairly simple document, and that's a document in which you appoint someone else, not like the power of attorney for financial purposes, but appoint someone else to make your healthcare decisions if you could no longer make them. Then you have a living will, not the last will and testament, living will, which sets forth your healthcare wishes. So while you're living, what do you want healthcare wise? And then living trusts. We do have a session only on living trusts. And when I lecture to attorneys on living trusts, those seminars are typically about 2 hours. So, you know, it's a bit complex, but we're going to go through some of the general aspects of trust today. We're just going to touch the surface, but then in session number, I believe it's number 3, we're going to dig our teeth into it, and you'll really understand why it's so important for most individuals to have a living trust. Okay, so let's start off with your last will and testament. And when I'm in front of a group live, and I've done some lectures for AARP and Schneps Media in the past, and one of the first questions I like to ask, I like the audience participation, say, what documents do you think someone should have or everyone should have? And virtually everyone raises their hand and says, yeah, we should have a will. Absolutely, you should have a will. But I want to go over the will today, you know, in a little more depth and explain what happens if you don't have a will, why it's so important, and how you could tailor that will to your individual needs and your wants. So all I could say is this virus has really made us confront our mortality. All of us in the New York City metropolitan area, we know people that have died of the virus. We know people, many people that have gotten the virus. A friend of mine, brother passed away just a couple of days ago with the virus. Our receptionist in our office passed away from the virus. My own brother passed away a couple of months ago from the virus. It's not from the virus, but if he was able to get care when he should have, when the virus wasn't raging out of control and he wasn't able to get into a hospital, I believe he still would be living. So we're all confronting our mortality, and we have to think about it. And I think it's making individuals realize that they can't sit on their backsides anymore. They gotta plan. And having these documents in order is a start. And it's a big start. So what is a will? A last will and testament is a document that you sign that sets forth where your assets go when you pass away. You could name any individual. You could even have a trust be your beneficiary. You remember Leona Helmsley, who gave $12 million to a dog. You could actually have a trust for your pet. Or more commonly on Long Island, we do these so-called pet trusts within our will for horses. You have many clients that also have horses, you know, so very interesting. So you can name virtually anyone, any charitable organization to be the beneficiary. So that's what a will does. But you need to tailor the will and the trust, if you do have a trust, and they need to work together. So I'll explain that when we talk about trust later on today and in more depth in a few weeks. So who are the parties to a will? Well, the individual that signs the will is called the testator, and the female testator is called the testatrix, T-R-I-X. We have the individual that manages the assets, et cetera, and distributes those assets. That individual is called the executor. The female executor is called the executrix. And then we have beneficiaries. You want to be the beneficiary, right? Beneficiaries get a benefit from the assets that have been probated, okay? The beneficiary could be a child, it could be a spouse. You could leave out anyone that you want, and we're going to get into that shortly. Or you can include anyone that you want. So you have total freedom. So beneficiaries, as I said, could be individuals, it could be family members, a charity, and oftentimes it's a trust. Many times I get asked, well, can the executor be a beneficiary? Of course. Like, take the example when you have just one child and you want to possibly leave all your assets to that one child. Who should be the executor? Why not have that child be the executor? Of course. Just so you know, the executor does get paid for what he or she does, but doesn't have to. The executor does get paid a statutory amount, and those fees are called commissions. So to give you an example, it might be 5% of the first 100,000, 4% of the next couple of 100,000, then 3% of the next 700,000. There's a schedule. But if you think about it and you started to take out your pen and paper and start to add up the numbers, well, that could be quite substantial. Some executors could actually get commissions on a large estate of over $100,000. So if you want to name someone as an executor, and you might say, well, I don't want to bother him or her, but I really would feel a lot more comfortable, just know they can get paid. And these are statutory, they're written in the law, written in the Surrogates Court Procedures Act. And the percentages that I gave you are the actual percentages starting off. So don't worry about that. They are getting paid for their job. Now, let's look at the next bullet point. You really want to tailor your will to your individual needs and wants. So important. So today I was working with a family and there's a child with special needs, very, very high functioning, and actually works as a musician, but is definitely on the spectrum. So instead of giving directly to that child, within the will, we can set up a trust within the will. That's called a testamentary trust. So in your will, let's say you have 3 children, I give 1/3 to child A outright, excuse me, 1/3 to child B outright, and 1/3 to child C who has special needs in this special needs trust. You can do that all within the will. And again, that trust is called the testamentary trust. And a special needs testamentary trust provides that that beneficiary won't get the assets outright and can stay on all of the benefits that they're on. Medicaid, they could stay on SSI, maybe stay on housing, and none of that would be affected by that trust. Even if you leave them hundreds of thousands of dollars, that would be within that trust within the will, so that child could stay on benefits. In the same way, let's say there's a child you don't want to give outright because they'll just squander the money, or you're worried about a child being ill or becoming ill, or a spouse of that child grabbing that money, which I hear every week. So I love my son, but I don't know about that daughter-in-law. Have I ever heard that? Every single day, in my practice. So there's something we can do about that if that strikes a chord with you. And let's say you wanted to leave out a child. Let's say you're estranged from a child and you want to leave out a child. Or you just want to leave out a child because maybe that child has millions and your other child or children might not have as much. There are ways we can put provisions in a will that would help to reduce the chance of a contest. There are lots of strategies that we could use to help or virtually eliminate a will contest. Now, I've been doing this for many, many years. I've been an attorney for about 40 years and doing this work for, I'd say, 35 years plus. And have we ever had a will of ours contested? Yes. Has any will, only a couple of times, but has any will been overthrown? Not a one, not a one. And I don't think that record is going to be turned over. So it's very hard to contest a will that's drafted correctly. So I want you to feel confident in knowing, especially if we take the right precautions, that that will, once you sign it, would be good. Let's look at that last bullet point, the spouse's right of election. Now, you remember I said you could leave anybody out of your will that you want. Can you also leave out a spouse? The answer is yes, you can leave out a spouse. However, if that spouse doesn't receive the greater of $50,000 or 1/3 of what you had when you passed away, and even that amount is even expanded with what we call testamentary substitutes. But let's not get too complicated. If you didn't give your spouse at least 1/3 of $50,000, that spouse can bring in a death certificate, that death certificate piece of paper, go to the court, not even prove anything, except that you were married at the time of death. Here's a death certificate. We were married. I want my third. And that's why it's called a right. So it's not a chance. It's not a maybe. If you were married, it's a right. And that's in the estates, powers, and trust law. So just be aware. So when you do your will, many times we do Medicaid planning. And you gotta think. So if we get a husband on Medicaid, should the wife give all of her assets to the husband who's on Medicaid, and has all these assets protected? Of course not. We probably will use a trust in the will, or maybe have assets go to the children. But we want to do actually more proactive planning than that. Many times people ask me, well, what happens if there is no will? Does everything go to the state? And the answer is no, not right away anyway. Assets, if there's no will, let's look at these bullet points. If there's no will and you have a living trust, well, assets will go pursuant to the beneficiary designation in that trust. But very importantly, because a lot of people don't realize this, it's so simple, but you need to transfer assets into the trust once we create that trust. So if we create a living trust for you, that's just a piece of paper. You need to transfer your co-op, your condo, the home, the Apple stock, or whatever it is, if you're lucky enough, into that living trust. That would avoid probate and will take precedence over the will. Beneficiary designations, the second bullet point, takes precedence over the will. So if you have a life insurance policy with beneficiaries, that's what will control, not the will. But be careful with beneficiary designations. It's limited, because with beneficiary designations, assets go outright with no extra protection. You may want assets held in a testamentary trust or divided up a certain way. So that's why a will is good, but the best is to have a will and a trust and make sure they talk to each other and that they work together. But if you don't have a will at all, do your assets go to the state? No, it goes to your family first. But then if you don't have any close family at all, then it might go to the state. So when you died without a will, we say you died intestate. Look at the third bullet point. And EPTL is a section of the law, the Estates, Powers, Trust section, States, Powers, and Trust Law section of the law. Section 4-1.1 is actually written in English, not so much legalese here. If you have a spouse, no will, no trust, no beneficiary designations, you have a spouse and no children, everything to the spouse. If there's a spouse and a child or children, then the spouse only gets 50,000 and 1/2. The balance goes to the child or children. Look how crazy that is. What if that spouse needed every penny of it to survive? Well, that's not what's going to happen. You need a will and a trust. And again, they should communicate with each other. If you have a child with no spouse, if you have no spouse and no children, everything goes to parents. And how many times has that happened in my practice where we got a mother on Medicaid, and all those assets were protected, and the son wasn't married, had no children, suddenly passed away from the virus. We've had this, and all the assets went to the parent who was on Medicaid. Bad planning, bad planning. You gotta plan. So if there's no spouse and no children, all assets go to parents. And if there's no parents, assets go to the descendants of the parents. And if there's no parents with descendants, it goes to the descendants of the grandparents, half on the paternal side and half on the paternal side. So that's the will. Now, you want to make sure that you have a power of attorney, but not just a form of the power of attorney. You want to have an expanded power. Why? Because God forbid, if you become incapacitated, or you can't manage your affairs, or God forbid, like we've had this during COVID, spouse is on a ventilator. We've had that several times during COVID, not lately, thank God. So what do? We have a power of attorney that's expanded, and we could do whatever we need. If that power is given to the spouse, let's say the husband could make all decisions, could step in, pay bills, manage the individual's business. If there's a trust, manage that as well. Do what needs to be done from A to Z. Take tax elections, sign tax returns, pay whoever needs to be paid. Even set up a trust, just like you could. So that's why we have to expand that power with maybe 20, 40, sometimes even more additional provisions into the power of attorney and also into that statutory gifts rider. What is that statutory gifts rider? It's a rider, an extra document that's attached to the power of attorney that lets us make gifts. You might ask, well, why is that important? Well, it's important because we may need to tweak a plan that was already done. Or, shame on you if you didn't plan, but we may need to do a plan, create a trust, tweak a trust, make certain payments that are required to be made without penalty. There are so many things that agent on a power of attorney could do. The power of attorney is only for financial matters in New York. If you actually Google power of attorney, you might see that it involves healthcare decision-making also. Yes, but not in New York State. In New York State, that power of attorney is only for financial matters. You want it expanded with a statutory gifts rider only if you trust the individual that you're naming. And if you don't trust that individual, there's a couple of things to think about. Number one, well, not much if you see us. If you don't trust the individual, you don't name that individual on the power of attorney, period, right? You want to be careful. But let's say you actually trust the son and you want to name your only child on that power, but you say, I love my son and he's great, but he's a great son, but he's not great with finances and I want to make sure he does the right thing. New York State allows you, and hardly anybody takes advantage of this, but I recommend it often. You may want to take advantage because New York State now lets you name a monitor on that power of attorney that can monitor the agent on the power of attorney to make sure that that agent is doing the right thing. You might have heard about situations where, the agent on the power of attorney overstepped their bounds, or someone might have actually stole some money and the DA got involved, blah, blah, blah. Well, it hardly ever happens to any of our clients, but a way to basically fight that is to name a monitor on that power of attorney. Okay. Now, when you have a power of attorney, you have a statutory form, then we add all of these extra provisions so that whoever you've named can actually plan for you. Now, when you sign that power, it's good right then and there, if you want it to be. So you sign that power of attorney now, then it's good right now, period. So let's say you're careful. Let's say you want to be at home because you have some health issues and God forbid, you don't want to get this virus. So that's fine. But let's say something needs to be done in person. It's happened to me too, where you got to do something in person. Well, your agent on the power of attorney can do that now. You don't have to wait till you become incapacitated if you don't want it. Or you can actually specify that the power isn't good till you're incapacitated. That's your decision. But you want a good power of attorney. Now, let's say you have 2 children. Could you name both of them to be agents on your power of attorney to act together? Absolutely. What if you have 3 children? Together or separately? Absolutely. Or you could name one at a time. And it doesn't have to be a child. It could be a friend. It could be a mentor. Probably shouldn't be your elder law attorney. Let them do their job. But someone that you trust totally with doing the right thing. Okay. So again, look at that last bullet point. The form of the power of attorney is fine for a real estate closing, but not fine for estate planning, elder law planning, Medicaid planning, saving on estate taxes. We need to jockey assets around, set up trusts, usually, and you need to have a special planning power of attorney to do that. So let's move on to the healthcare proxy. So the power of attorney gets to be a pretty complex document, but we simplify it, simplify it for you, but it is complicated for us. On the other hand, a healthcare proxy is quite simple. Healthcare proxy is similar to the power of attorney, but the power of attorney is a document in which you appoint someone else to make your financial decisions, set up a trust if you have the extra provisions, do what needs to be done, pay bills, etc. The healthcare proxy is where you appoint someone else to make your healthcare decisions. Look at bullet point number 2. Unlike the power of attorney, you can only name one at a time on the healthcare proxy. What if you have 3 children? Well, got to pick who you're going to name first, second, and then third, if you want to name your children at all. So this document is fairly simple. There's only a few, not like the power of attorney that we have so many extra provisions to give it the teeth it needs. The healthcare proxy, we only add a couple of extra provisions to the statutory form, and then you'll have a good healthcare proxy. But I can't emphasize how powerful that healthcare proxy is, and it's recognized by every facility in New York State. You would want to use the form that New York State has. I suggest that you tweak it a little bit. Look at bullet point number 4. You want to establish that you discussed your wishes regarding feeding tubes with your agent, because under New York law, otherwise they won't be able to make decisions about feeding tubes, probably why you're doing this healthcare proxy to begin with. So have the elder law attorney, such as myself or whoever you'd like to use, add that provision to the power of attorney. That's really the most important provision you would want to add. Never put a time limit on that healthcare proxy. I saw clients who did that and something happened to them. So they said, well, this proxy is good when I come back from vacation, on December 30th. Well, then they forget about doing it. There is a place to say if you want it indefinitely or when is this valid until, make sure it's going to be valid indefinitely. Now, this healthcare proxy is very easy to sign. You only need 2 witnesses. Those witnesses should not be anyone you named as a proxy on the document. You don't need a notary, but it's also a good form to do something that can help someone else, is make an organ donation. I had, unfortunately, a friend who passed away from the virus, had actually a lung transplant. Lasted for a little while, but the COVID really got to him. So you want to just make sure that, if you feel comfortable with making an organ donation, the healthcare proxy is the right vehicle. Actually, before I get into the living trust, and I know I just have a few more minutes, I do want to say you could and should also have a living will with the healthcare proxy. A living will is where you set forth what your healthcare wishes are. So not like the last will and testament, where your assets go when you pass away. Your living will might say you don't want to be kept alive artificially if there's no chance of recovery. It's good to have that, because when you name an agent or a proxy, that individual needs to know what you want, and that individual may have to make some decisions that they may not be happy about making, but they have to make your decisions, not theirs. So sometimes it's good to put that in writing. And when you think about who your proxy is going to be, make sure you're going to name somebody that, number 1, knows what you want. Number 2, you know that they're going to make the decisions that you want, because they have to by law, but you want to double check. So if you have let's say your eldest son, could never pull the plug, even if you're, God forbid, in a vegetative state, but that's what you want, don't name your eldest son. Think about who you name and have a living will as well. So you put in writing, what you want health-wise. And always, always speak to the proxy. Let them know what you want and don't want. They're not going to know by osmosis. So you need to go over with them in detail, what sort of healthcare decisions would you want made in the future if you can't make them yourself. And when you think about it, these are great documents to have, because you cherry pick, you hand pick who you want to make decisions if you can't make them. And of course, with the power of attorney, obviously the statutory gifts rider attached to that power of attorney, the healthcare proxy. Upon death, these documents are no longer effective. How many times have I gotten calls asking, well, I have a power of attorney, my mom just passed away, I'm going to use this power of attorney and go to the bank, blah, blah, blah. Well, just at the time of death, that power of attorney is no longer good. So just be aware. Okay. Now, in the last session for AARP, we're going to go into living trusts. And we're going to dig our teeth into living trusts and how it could protect assets for Medicaid, how we could do Medicaid planning with it, estate planning with it, special needs planning with it, preserve assets, windows of opportunity that we have before year end. Clients are a little concerned, not to be political at all, but about a Biden administration. Might the tax laws change because President-elect Biden has a tax plan that he was talking about? Might it affect your situation if it does get passed? So you want to do this planning in advance, and almost all of this type of planning involves a living trust. Now, I just want to step back for a minute. There are two basic types of trusts that we're going to deal with. There would be a testamentary trust, we discussed, that's a trust within a will. Then we'll have a living trust, a trust that's signed now while you're living. A testamentary trust, the trust in a will, isn't effective until the will is probated, then the trust comes into being. The living trust is effective right now. You sign it today, it's effective today. And we could do so much planning with that living trust. We could protect state taxes, gift taxes, save or eliminate capital gains taxes, even income taxes for certain individuals. We avoid probate, and there's so many different reasons to have the trust. And just getting back to basics, people ask, you know, Ron, you talk about trusts, but what is a trust? It's very simple. Trust is a vehicle. It's a vehicle, like, think of it like an envelope that holds assets. And you have the individual that creates the trust. That individual is a grantor, settlor, or creator. That individual creates the trust, sets up the rules in that trust. How are the assets to be managed? How are they to be distributed, etc.? The trustee manages the assets, distributes them according to the rules created by the individual that created the trust, the grantor, the settlor. So can the grantor be the trustee? Yes, but maybe not in certain types of trusts. And then you name different types of beneficiaries. So a living trust is the gold standard to protect assets. And we're going to get into that in much greater depth in a few weeks. So you might ask, Ron is talking about all of these documents. How are we going to get these documents signed? I don't feel comfortable going to his office or anyone's office. We're in the midst of a pandemic. The numbers are going up. We're listening to Governor Cuomo on TV, and we see what's going on. You know, I'm going to put this off. Well, I'm here telling you now, don't put it off. You don't know what the future could bring. And thanks to the governor, we now can execute all of these documents. We can get them signed, sealed, and delivered, notarized, and witnessed. These are the two slides that explain the process. It's very simple. You could be in your living room or sitting at your kitchen table, and we could be talking on Zoom or a medium just like this or FaceTime, whatever it is, and we can have all these documents signed and witnessed by individuals who are not with you. So there's no fear about getting this virus or contamination or anything else. You don't have to go anywhere. The whole process from beginning to end can be done very simply. I don't think I have enough time to go into this, but we could make these slides available for anybody that wants them, if you'd like. And it goes over the procedure for how to do the virtual notarization. And the next slide is the virtual witnessing. So I do know that it's 2:45 and my time is up. This is me. If anybody wants to know who I am or how to spell my last name, I was talking to Bernard about that earlier. So let me stop sharing my screen. All righty. Thanks so much. I really do appreciate it. Thank you, Elizabeth. And thank you so much, Bernard, to both of you for having me.
Wow, Ron, that was really fantastic. You gave so much wonderful information. We do have a bunch of questions. Let me just, if you would be so kind as to give us a few more minutes of your time, may I just ask a couple of them?
Sure, of course.
Really, this information is invaluable. So someone was asking, what happens if the person that you designate through power of attorney becomes incapacitated himself?
That's why we always have, let's say, my two children together. If one passes away or one can't act, the other one will. If not, we have a successor. But let's say there are no successors. Unfortunately, in that case, we may have to bring a guardianship action.
Okay. Another question in regards to power of attorney too, you had mentioned executors being paid. Do power of attorneys get paid as well?
Very good question. They can be paid. You know, and this is fairly recent. They can be paid. So if you want that to happen, you could put a provision in that power of attorney so that the agent on the power of attorney can be paid. So you control that.
Okay, thank you. Helen wanted to know, if you have beneficiaries to your insurance or 401k, do you really need a last will and testament?
Well, the beneficiaries on your 401k will be getting those assets. Very simple. You just go to, contact the 401k company and say, my husband, my father, mom passed away. Here's the death certificate. I'm the beneficiary. You want to speak to your attorney and advisor. You want it to be, if it's a retirement account, trustee to trustee, because you can take those assets over a 10-year period now, not over a lifetime, but you want to make sure you take advantage of at least that 10-year period. And so make sure that your financial advisor and attorney get involved just so you make sure that you take advantage of that. You don't want to just take that asset outright. You really want to do it trustee to trustee, and you should be good. But you always want a will. So there might be another asset that you forgot about. We had a client that didn't realize about her Israeli bonds, which were about $75,000, totally forgot. She passed away. We had the will. So we know she had beneficiaries on everything else. And, but the best way, again, is to have that living trust. Not for the 401k, you never transfer a retirement account into a living trust. You might have the living trust be the beneficiary of a retirement account, but never transfer a retirement account into a trust. Because, for example, an IRA is an individual retirement account. You transfer that into a trust, it's no longer your retirement account. The IRS is going to want you to pay taxes on all that money unless you put it back within 60 days. So that's the general rule. So you have to be very, very careful. But invariably, your diamond engagement ring, where does that go? You don't have a beneficiary on it. The will, goes over. Where do your personal effects go, etc. Sorry, Elizabeth.
No, not at all. I just wanted to finish on the question of, obviously so there's so much information, why is it that it is important to go to a professional when dealing with all this? People see things on the internet and, maybe someone has a friend who's a divorce attorney. Why is it important to go to somebody who has expertise in this?
It's a very, very good question. before I did what what I'm doing right now, and I have for so many years, I thought it was simple. Transfer assets into a just it's simple. You could go to anyone, but there are so many nuances that could make or break something. We had a client that didn't set up a trust right and caused $3 million to be taxed in their estate. Yep. And it was a little tweak in a trust. No good. We've had many clients that went to a general practitioner, not an elder law attorney, and did some Medicaid planning. And several of those trusts were not done right. Yeah, they were irrevocable, but there are little tweaks that will just absolutely make or break it. You need to go to a professional. You won't know or even think about it. Even a will. If you go to a place, you've got like a LegalZoom, and you get a will done, and then you need to get that will probated later on, there's no presumption that the will is good. The only big issue that we ever had in my firm, it was a huge issue, was with a will done on LegalZoom. And there was no presumptions. If we do it as a firm, or good attorney does a will the right way, it's deemed to be valid. We have an affidavit and it's all right. And so that presumption in the surrogate's court is huge. It's presumed to be a valid will. So it's very hard to contest. And that's why we've never had a successful contest to a will. But the LegalZoom will was contested, and that was an issue.
Thank you so much. My goodness, we could keep you here all day long with all of these wonderful questions, but we do have to wrap up. I do want to say thank you so very much
Sure,
for being
thank
here
you.
and answering those questions. We're not done. I just wanted to introduce now to everyone Antonio Coppola, AARP Associate State Director from New York City, for some closing remarks, and then stay with us for a short video.
I want to thank you all for participating in the first of a three-part webinar series on financial wellness, hosted by Schneps Media and sponsored by AARP New York. My name is Antonio Coppola, and I'm the Associate State Director for Community Engagement for AARP New York City. We know communities around the world are facing some of the most challenging times in generations. AARP is working to ensure that you have the financial security you need to take charge of your future and live independently as you age. We're focusing on supporting the communities throughout the state with opportunities to connect without ever leaving the home. We're offering many ways to keep you engaged and informed online. So connect with AARP New York at aarp.org/nearyou to learn more about at-home activities, classes, wellness, upcoming events, and volunteer opportunities in your area. Or you can find us on Facebook at facebook.com/AARPNY to participate in free conversations with local and state leaders who talk about issues such as health, finances, or scams that are happening in your area. Thank you so much for being here with us today.
Thank you, Antonio. And please stay with us for a moment.
Hey! Hi! It's time to crack an egg.
Easy, any style egg works.
Or smile.
Well done, this looks great.
Time to share a story.
I have a great way to start our discussion.
With old friends or new ones.
When you're a caregiver.
Time to breathe in.
Inhale up, good job.
Then let it all out.
Rah!
It's never been easier to connect, learn, and have fun.
Cheers.
So let's do it together. Come find us at aarp.org/nearyou.
Thank you, everyone, for spending some time with us this afternoon. A big thank you to Ron Fatoullah, and a huge thank you, Bernard, Antonio, and AARP for presenting this important and valuable webinar. Please visit Schneps Media's YouTube channel, where you'll be able to see a recording of this, and also visit schnepsmedia.com/webinars, where you can sign up for the upcoming webinars on December 9th, where we will be talking about the changes in the Medicaid law starting April 1st, 2021. And then on December 16th, Ron will take a deeper dive into trusts. So please be sure to join us for those. Again, thank you so much. Please, everyone, stay safe, stay healthy, and we'll see you soon. Bye-bye.